A federal grand jury in Texas wanted 6 years of medical files, not financial records, not business documents, medical files belonging to minors. On May 7th, a hospital in New York City was served with a subpoena. It demanded the identities of every patient under 18 who received a specific kind of medical care going back to January 2020. Names, diagnoses, treatment histories, parental consent forms, everything. The justification the Department of Justice gave? An investigation into misbranding, a technical drug labeling violation usually reserved for pharmaceutical fraud cases. That's the legal cover story they used to reach into the private medical files of children. 9 days later, this went to a courtroom in the Southern District of New York, and on the other side of the bench sat a judge who wasn't buying it. She didn't just deny the request. She used words like egregious. She said she was hard-pressed to trust the government's own promises about what it would do with the information, and she pointed to something the Justice Department couldn't hide from her. This wasn't their first attempt. It was their latest attempt, after at least 8 other federal courts had already shut the same request down. So the question isn't just, did a judge block a subpoena? The question is, why does the federal government keep trying to get its hands on the same private medical records, court after court, state after state? And what happens on July 8th when this judge has to decide if her temporary block becomes permanent? That decision is coming, and the paper trail leading up to it tells you almost everything about how this fight actually works. Here's the headline, stated plainly. On Wednesday, June 24th, U.S. District Judge Katherine Polk Failla issued a temporary restraining order blocking the Trump administration's Department of Justice from obtaining sensitive medical records on transgender minors from New York City hospitals, including NYU Langone. Ruling from the bench, Failla found that the subpoenas issued through a federal grand jury sitting in the Northern District of Texas likely violated the Fourth and Fifth Amendment rights of the patients involved. She provisionally certified a class covering anyone who received this kind of care from a New York City provider over the past 6 years. That means this order doesn't just protect the handful of named plaintiffs who sued. It protects an entire class of people whose names DOJ was trying to obtain in the first place. The restraining order is temporary by design. 14 days, according to its terms. But it buys time, and it sets up the real fight. A hearing scheduled for July 8th, where Failla will decide whether to convert this temporary block into a preliminary injunction, a much longer-lasting order that would keep DOJ locked out while the underlying lawsuit plays out in full. For now, the records stay sealed. The subpoena stays unenforced. And the Justice Department has to explain, in writing and in court, exactly what it's actually investigating, something it has struggled to do consistently in this case and in the 7 or 8 cases that came before it. If you're coming into this cold, here's what you need to know. Katherine Polk Failla is a U.S. District Judge for the Southern District of New York, appointed by President Obama. She's not a newcomer handed a politically loaded case out of nowhere. She's now one of a growing list of judges, appointed by presidents from both parties who've pushed back on how this administration's Justice Department has gone about a specific kind of investigation. That investigation centers on gender-affirming medical care for minors. Over the past year, DOJ has tried repeatedly to get hospitals and clinics around the country to hand over patient records tied to that care. First through administrative subpoenas, a lower-level tool that doesn't require a grand jury. At least 8 federal district courts blocked those attempts. One court called the government's reasoning a smokescreen. Another concluded DOJ had issued the subpoena first and gone looking for a legal justification second. When the administrative route kept failing, DOJ escalated. In May, prosecutors went through a federal grand jury in Fort Worth, Texas, a venue widely seen as more sympathetic to conservative legal arguments, and used that grand jury's authority to subpoena NYU Langone Hospitals directly. The demand: identify every patient who received this care as a minor from January 2020 through May 2026 and hand over the full record from first consultation to the most recent treatment. Other hospitals, including Mount Sinai in New York and Stanford's Lucile Packard Children's Hospital in California, are believed to have received similar demands. In response, 3 families with transgender children and 2 transgender young adults, all suing under pseudonyms to protect their identities, teamed up with the ACLU, the New York Civil Liberties Union, and Lambda Legal. They asked the court for an emergency order before any records could be handed over. That's the fight that landed in front of Judge Failla. And it's a fight with a much longer backstory than any single subpoena. Let's lay out how we got here, beat by beat. Over the past year, the Department of Justice begins issuing administrative subpoenas to healthcare providers across the country, seeking records tied to gender-affirming care for minors. Courts start pushing back almost immediately. Across at least 8 federal district courts, judges block these subpoenas outright, questioning whether DOJ actually has a legitimate criminal investigation behind them at all. May 7th, 2026, NYU Langone Hospitals in New York City is served with a new kind of demand, not an administrative subpoena this time, but one backed by a federal grand jury sitting in Fort Worth, Texas. The scope is sweeping. Identify and produce records for every patient who received gender-affirming treatment as a minor, from January 2020 through May 2026. Other institutions, including Mount Sinai, are believed to receive similar demands around the same time. Shortly after, Stanford's Lucile Packard Children's Hospital confirms publicly that it, too, has received a grand jury subpoena as part of the same nationwide effort. Patients from that hospital begin seeking their own court protection. June 2026. 3 families of transgender youth and 2 transgender young adults, all of whom began care as minors, file suit in the Southern District of New York. Their legal team, the ACLU, the New York Civil Liberties Union, and Lambda Legal, all plaintiffs proceed under pseudonyms. Their argument, handing over this information would expose them and their families to a real risk of retaliation, and the demand itself violates their constitutional rights to privacy and protection from unreasonable search and seizure. Days before the ruling, Failla hears oral arguments. According to her later comments from the bench, Justice Department attorneys leave the door open, deliberately or not, to the possibility that the records could eventually be used to pursue patients or parents themselves. That single exchange becomes central to her decision. Wednesday, June 24th. Ruling from the bench, Failla grants the emergency request. She provisionally certifies the class. She issues a 14-day temporary restraining order, barring DOJ from obtaining the records by any means, including the grand jury subpoena already sitting at NYU Langone's door. Now, the clock is running on that 14-day window. A follow-up hearing is already on the calendar for July 8th, the date that will determine whether this protection holds or whether it expires and the fight starts over. That's the buildup. Now, here's the moment that actually mattered inside the courtroom. Here's where the case turned. And it didn't turn on a document. It turned on something the government's own lawyers said out loud, one day before the ruling. On paper, the Justice Department's justification for these subpoenas has stayed consistent. This is a criminal investigation into misbranding, meaning the improper labeling or off-label distribution of FDA-approved medications used in gender-affirming care. According to reporting on the case, a special agent from the FDA's Kansas City Criminal Office was the one who initiated the underlying request. On its face, that's a real legal category. Misbranding investigations exist. The FDA does pursue them. But here's the contrast Failla zeroed in on. A misbranding investigation is supposed to be about drug manufacturers, distributors, or prescribers, not about identifying and compiling a list of individual patients who received illegal medical treatment. The subpoena to NYU Langone didn't ask for prescribing records in the abstract. It asked the hospital to produce documents sufficient to identify every patient who underwent this care, along with the complete treatment file for each one, and separately, the parental authorization records tied to each minor patient. That's the gap between the stated legal theory and the actual scope of the demand. And when Failla pressed DOJ's attorneys on it during oral arguments, she got an answer that made the gap worse, not better. According to the judge's own comments from the bench, government attorneys would not commit to a guarantee that the patients or their parents wouldn't eventually face prosecution based on what these records showed. Failla said she was, in her words, hard-pressed to accept DOJ's assurances on that point, especially given prosecutors' inability to comment on the actual scope or basis of the investigation itself. Sit with that for a second. This wasn't an outside critic accusing DOJ of planning to target patients. This was the judge describing what she heard directly from DOJ's own lawyers under her own questioning on the record. That's the core contrast of this entire case. A narrow technical legal justification on paper, misbranding, drug labeling, FDA authority, versus a demand broad enough to identify every minor patient in a 6-year window, defended in court by attorneys who wouldn't rule out prosecuting the patients themselves. Newsweek's reporting adds another data point that matters here. At NYU Langone alone, Failla noted that at least 40 patients received this care during the window covered by the subpoena. 40 names, 40 full medical histories, 40 families, all sitting inside a document request built on a legal theory that couldn't survive its own courtroom questioning. This is why Failla didn't just deny the subpoena on a technicality. She granted class action status. She issued a restraining order broad enough to block not just this specific request, but any similar attempt to reach the same records through the same grand jury. And she scheduled a hearing, July 8th. Specifically to determine whether this protection should become permanent, rather than letting it quietly expire in 2 weeks. The evidence in the end wasn't a leaked memo or a smoking gun email. It was DOJ's own lawyers standing in front of a federal judge, unable to promise the one thing that would have made their entire justification credible. If this were an isolated case, one overreaching subpoena, one skeptical judge, it would still be a significant ruling. It's not isolated. And that's where the stakes climb. Failla didn't rule narrowly. In her comments from the bench, she went further, describing the government's pursuit of this information as targeting a uniquely vulnerable group and calling the effort most egregious. She tied it explicitly to a broader pattern, one she said stretches back to the administration's earliest days, of actions aimed at transgender Americans specifically. That's a judge doing more than resolving a discovery dispute. That's a judge stating, on the record, that she sees this subpoena as part of a sustained campaign rather than a one-off investigative decision. And the facts support that, Red. This is not the first subpoena fight of its kind. It's at least the 9th. 8 other federal district courts already blocked earlier versions of this same records demand when DOJ tried it through administrative subpoenas rather than a grand jury. One of those courts flatly called DOJ's stated reasoning a smokescreen. Another concluded that prosecutors issued the subpoena first and searched for a justification second, meaning the legal theory came after the decision to go after the records, not before. Now add Stanford's Lucile Packard Children's Hospital into the picture. It isn't just New York. A separate group of patients on the West Coast is fighting the same battle over the same kind of subpoena from the same underlying nationwide effort. That means whatever happens in Failla's courtroom on July 8th won't be the final word. It's one front in a fight playing out in multiple states and multiple courtrooms simultaneously. And here's the contradiction that raises the stakes even further. This pattern isn't limited to medical subpoenas. Around the same period, a separate federal judge in Minnesota found that grand jury subpoenas targeting Governor Tim Walz and other state officials were retaliatory, issued, according to that judge's ruling, to punish Walz for refusing to cooperate with the administration's immigration enforcement priorities. Different subject, different state, same underlying question. Is the Justice Department's subpoena power being used to investigate actual crimes or to pressure and punish people the administration has already decided are targets? That's the turn. What started as a hospital records dispute in New York is now sitting inside a much larger, much more consequential question about how far federal prosecutorial power reaches and who gets to decide when it's gone too far. DOJ, for its part, isn't conceding any of this. And their side of the argument deserves a real hearing, not a dismissal. It's worth being precise about what the Justice Department is actually arguing, because the Steelman version of their position is stronger than they just want to target trans kids, and treating it that way undersells what's actually being litigated. DOJ's formal position is that this is a legitimate criminal investigation into misbranding, a real prosecutable offense under federal law when medications are distributed or promoted for uses not approved by the FDA or when labeling requirements are violated. The government has broad, well-established authority to use grand jury subpoenas in pursuit of that kind of investigation. Grand jury secrecy rules also mean DOJ is legally restricted in how much it can say publicly about an ongoing probe, which is a real constraint, not just a convenient excuse. Prosecutors can't fully lay out their theory of the case in a public courtroom without potentially compromising the investigation itself, and courts do generally give some deference to that constraint. DOJ can also point out accurately that this case has not been decided on the merits. What Failla issued is a temporary restraining order, an emergency, short-term measure meant to preserve the status quo while the underlying legal questions get fully briefed and argued. It is explicitly not a final ruling that the subpoenas were unlawful. The July 8th hearing exists precisely because the legal question is still open. DOJ will have the opportunity to make its full case for why a grand jury investigating drug misbranding needs patient-identifying information as part of that inquiry, and why the scope of the request, 6 years, multiple hospitals, is proportionate to a legitimate investigative need. It's also fair to note that not every court has ruled against DOJ's subpoenas in this space, and the administration maintains publicly that it has a duty to investigate potential violations of federal law regardless of the population involved, arguing that treating one category of investigation differently because of who it affects would itself be a form of selective, politically driven enforcement. None of that erases what Failla found troubling: the inability of DOJ's own attorneys to rule out prosecuting patients, or the pattern of prior courts questioning the government's stated rationale. But it does mean the honest framing here is a federal judge found this specific attempt legally deficient and paused it, not a court has ruled DOJ's entire investigation illegitimate. Those are different claims, and the difference matters because it's exactly what July 8th is going to resolve, one way or the other. Here's why this isn't just a story about one hospital, one subpoena, or one political fight. Even if you have no personal connection to gender-affirming care at all, the legal question at the center of this case is bigger than its subject matter. How much medical privacy do you actually have when the federal government decides it wants your records and is willing to use a criminal investigation, real or pretextual, as the legal vehicle to get them? Grand jury subpoenas are powerful tools specifically because they operate with less public scrutiny than most legal processes. That's by design, for legitimate reasons: protecting ongoing investigations, preventing evidence tampering, safeguarding witnesses. But that same secrecy is exactly what makes it hard for the rest of us to know whether the tool is being used narrowly and appropriately or broadly and punitively, until a judge like Failla gets a look at it and says so publicly. If a legal theory this thin, a misbranding investigation stretched to justify identifying every patient who received illegal medical treatment over 6 years, can survive a first round of judicial scrutiny, it doesn't stay contained to one patient population. The same tool, the same legal reasoning could reach reproductive health records, mental health treatment history, addiction treatment records, or any other category of care the federal government decides in a given political moment it has an interest in. That's the actual precedent being fought over here, not just for trans patients and their families, but for the basic proposition that your doctor-patient relationship stays private unless the government clears a real, specific, well-justified legal bar to get inside it. Failla's ruling suggests the bar wasn't cleared this time, but this time is doing a lot of work in that sentence, because the outcome on July 8th determines whether that bar holds or whether the door stays open for DOJ to come back and try again, in this case or the next one. So here's where this actually stands right now as of this video. The temporary restraining order Judge Failla issued is exactly that, temporary. 14 days by its own terms. It's not a finish line, it's a pause button, and the clock on that pause button is already running. On July 8th, Failla holds the hearing that decides what happens next. If she converts the TRO into a preliminary injunction, the block on these medical records stays in place for the full duration of the underlying lawsuit, meaning DOJ is locked out of NYU Langone's records, and likely Mount Sinai's, for months, possibly longer, while the case is fully litigated on the merits. If she doesn't, the protection could lapse, and the Justice Department could be back in a position to enforce the exact subpoena we just spent this video breaking down. And remember, New York isn't the only front. Stanford's Lucile Packard Children's Hospital is fighting a parallel battle in California right now over a subpoena from the same nationwide effort. Whatever legal reasoning wins or loses in Failla's courtroom on July 8th is going to shape how that fight and any future ones get argued. There's also the open question this video raised and didn't fully answer. DOJ's attorneys wouldn't commit in open court to a guarantee that patients wouldn't eventually be prosecuted based on what these records showed. That statement is now part of the public record. Does DOJ walk that back before July 8th? Do they offer the court a narrower version of the subpoena to save the underlying investigation? Or do they stand by the original scope and let a judge who already called their effort most egregious rule on it again? We don't know yet. Nobody does. Not with any certainty. That's exactly why July 8th matters and why this story isn't over just because this video is. If you want the ruling covered the moment it happens, not days later, buried under a dozen other headlines, that's what this channel exists for. Subscribe, turn on notifications, and I'll bring you the outcome the same way I brought you this. Sourced, in context, and without pretending to know what a judge is going to do before she's actually done it.